Any mention? Meet this, Your Lordship. Your Lordship, I beg to mention item number 9, Your Lordship.
Yes.
I'm praying for some more time, Your Lordship.
No objection, my lord.
This is also Nakma matter.
Not my matter.
2 weeks may be granted, Your Lordship.
It will be 3 weeks, my lord.
3 weeks.
This is a new matter, my lord. 2020 matter.
And for the private respondents, number 4 and
Just saying 3 weeks on the request of the petition. Yes.
Much obliged.
Please, Your Lordship. Lordship, I beg to mention item number 4, Lordship.
This is also not my matter, my lord. This was also partially heard.
Lordship,
What is the issue here, Mr. Des?
So again, my lord, the CM and EM order are under challenge, my lord.
And the grounds taken are same. That no issues were framed.
Yeah, those are the grounds only, my lord. These are the only common grounds which are available
In all the matters.
in all maximum matters, my lord.
Yes.
2 weeks, Lordship.
Let it come after 3 weeks.
Why after 3 weeks, Mr.?
Well, maybe I will be out of station.
This also at the request of the petitioner. This is matter. Yes.
Obliged, Lordship.
Lordship, I beg to mention item number 11 of the main list, Lordship. Lordship, in this case, we are supposed to receive the charge sheet, Lordship. However, we have not received the same. So, Lordship, I'm praying 1 week's accommodation, Lordship.
This is a petition for quashing.
Lordship. Criminal.
And who is paying for the state? You are for the private respondent.
Lordship.
You're supporting his case or opposing?
Lordship, I'm appearing on behalf of N.M. Mansoori.
Yes, NDM.
I'm appearing on behalf of N.M. Mansoori for 3 and 4, Lordship.
So you do not know. Yes. When?
1 week, Lordship.
1 week. Do the matter in 1 week. Urgent for 1 week. At the request of the learned counsel for the petition. Yes.
Lordship, a similar prayer for item number 10, Lordship.
Item number?
10, Lordship. This is that matter, Lordship, regarding disconnection of electricity, Lordship. However, Lordship, learned senior is leading us in this matter. I'm praying, Lordship, 1 week's accommodation.
What is the purpose of keeping this matter for such a long time?
Lordship.
Dispute regarding payment of bill. And you say that your connection has been disconnected.
Lordship. Here the issue of law remains, Lordship. That is the only
More
thing,
than
Lordship.
4 years now, you are remaining like this. Then what purpose is served by this litigation?
Lordship may have it next week, Lordship. We can endeavor to take up this matter.
Okay, number 10 also. After 1 week, it's a request of the petition. Yes. Yes.
Hello.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 2, Your Lordship.
Yes.
Lordship, I pray if this matter may come after a week, Your Lordship.
Item number 12.
2, Your Lordship.
Why Dr. Mojika is not well till now.
Yes, Your Lordship.
After 2 weeks.
After a week.
After a week. You've done after a week?
Madam.
Okay. You say item number 2. And the request made on the Dr. N. Mojika, Lanesh DSJ. This is matter after a week. Yes.
Much obliged, Lordship.
My Lord, I beg to mention item number 3, my Lord. This matter, my Lord, Mr. Thapa is not available today, my Lord. He has some personal difficulty, my Lord. So,
This is that Ranja.
supposed to place some
Lordship.
instruction, my Lord.
What is there for you in this case?
Praying after a week, my Lord.
Yes.
We have no objections, my lord.
You are for the state.
Lordship.
This also after a week.
Obliged.
Obliged.
Yes.
Lordship, I beg to mention item number 6.
Lordship, kindly have this matter after 2 weeks as Mr. Philemon Longbury is indisposed.
We have no objection, Your Lordship.
This is just like 2 weeks.
Lordship, I pray a similar prayer for item 8 as well.
Item?
Item 8, Lordship.
Nothing remains for this court. You see. No work is left.
Yes, Lordship.
Okay, both 6 and 8. They're also here for the petitioner.
Yes, Lordship.
Yes, Mr. Chandra 8.
It, Lordship, no objection.
You are there.
I'm for MPSC, Lordship. No
No service matter.
Lordship.
You are appearing for MPSC.
Lordship.
Selection.
Lordship. Selection process, Lordship.
Is it for the post of
For the post. Ayurvedic doctor.
Ayurvedic. 6 and 8 also. 2 week. For the request to the petitioner. Yes.
Highly obliged.
Obliged, Lordship.
Accused made on behalf of
Supplementary causes. Item
right
number
to
1.
property depending on things. Yes.
Me please, Your Lordship. Lordship, I pray if this matter may be taken up next week, Your Lordship.
I have no objection, my lord.
What is this matter about?
My lord, this matter is about challenging the order dated 0904-2024, my lord, wherein the learned trial court has dismissed my bail application by touching the
This is
merits of the
identical
case.
to that case which came up day before yesterday or something like that. Is it something like that?
But the question here involves a
Lapse of
different.
statutory period and the extension of time.
No. That and this is totally different, my lord.
This is what?
This is a criminal revision, my lord, challenging the order dated 09.
This is matter, bail matter.
My lord, yes, my lord, it's a bail matter which.
How a revision will lie in a bail matter?
My lord, I have filed a revision challenging this order, my lord, because if this order will maintain its finality, my lord, then it will affect.
How a revision lies in the bail matter? Bail is interlocutory order. There is no dispute. How a revision will be maintainable?
My lord, dismissing the bail order is a final order, so revision is maintainable, my lord.
Dismissing the bail order is final order.
Yes, my
There
lord,
is
it
judgment.
attains its finality, my lord.
Is there a judgment like that?
My lord, I'll satisfy your lordship.
Okay. Just say. The request made on the behalf of Dr. N. Mujika. Under DSGI, appearing for the respondent. This is matter after a week.
After
Highly obliged, my lord.
much obliged, Lordship.
This will come in the motion column. This will come in the motion column.
Very causeless. Item number 1.
This matter where my lunch friend has taken a adjournment on the last occasion, my lord,
Lordship,
to complete his instruction.
Your Lordship, there is a, of course, there is a, I should say, there is some defect in my petition. So, since I have stated the argument that there was no framing of charge, no recording of statement. So, Lordship has pointed out, of course, in my petition, I have not clearly mentioned that those. But I have generally make a statement that procedure have not been followed. Lordship, I am
No,
saying that,
Madam, charge is
Lordship,
not
no,
framed.
let me complete. I am just saying that I may be allowed to withdraw. I will file with a liberty to file because, of course, in the defective petition, the pleading or Lordship,
You want to withdraw with the liberty to file a plea.
Lordship, I will file it.
No, I have objection. Because it has gone more than 11 years for this.
But then
And the
that
lady
is
now
what was
78
suggested
years.
by the other
Yes.
the other day. It was the suggestion which came from Mr. Day.
Yes, I have suggested him because the draft was not
So
proper.
you basically lead him to something and then subsequently you disagree.
No,
It's
because
not
my
very
lord,
clear.
here, a few facts that I also find it out subsequently to my suggestion that whether the drafting was done proper or not, that is not an issue here, my lord. But the issue is this, my lord, whether the lower court or the CM and EM court has followed certain procedure or not. But the record says otherwise. The record speaks volume, my lord. Now, okay, fine. I have suggested him to withdraw it, my lord. I have not suggested him to withdraw with liberty, my lord. That is one thing. Second thing, my lord, whether if it was to be very clean, my lord, my submission I am submitting that if the issues was not framed, then my lord, yes, fairly.
You are having the record with you.
Yes, my lord, this. The order sheet is there. Now, my lord, may I kindly see what was his case, my lord? His case was that he is not heard by the trial court, my lord. But here is the written argument that he has submitted.
That is one thing, but then his
Now-
main argument was that no issue was filed. The Doresama case was not followed. The proposition laid down in Doresama has not been followed.
No, that is also not correct. No, that is also not
difficulty
correct.
was that there was no specific statement with regard to that in writ petition.
Yes, my lord. My lord, on 17/7/2014, my lord, both parties are present and represented. Both the parties has filed their suggested issues and issues are accordingly framed. Fixed on 14/1/2015 for hearing on issues of law. So now issues has been framed.
That is, see, precisely that is what has been noticed by this court.
Yes.
That his submission and the material on record do not tell you see, like it speaks. So now say supposing if at all he wants to refute something which is reflected in the order of the authority, then in such a case there has to be a specific plea which
Yes.
is missing.
Yes.
Which is missing. That is what the problem is.
And moreover, my lord, if my lord see the order sheet, my lord, on two
You have this record.
order sheet
the
is
entire
there.
record.
The order sheet is there with me. Yes, the entire record is
The
there.
order
But
sheet-
order sheet, I have classified the order
No,
sheet.
whether issues are framed or not.
Yes, the order sheet speaks so.
The issues are there.
Yes, definitely. I will.
What are the issues? These are there. How many issues?
My lord, I have to classify that, my lord. How many
Yes.
issues has been framed? Because here the order says, my lord, if I can show, my lord, OP present and represented petitioner filed the plea for adjournment due to this. But hearing on issues was done of law and even in EA, my lord.
That is what you understand. You see, you do not have to go. You see, like even his document says
My lord, yes,
the
yes.
document which he has appended with his writ
Yes,
petition,
yes.
that
yes.
also says
Only because my intention or contention before this honorable court was this, my lord, that the submission which has been made by my learned friend, my lord, is not correct. The records speak otherwise, my lord.
What I'm trying to say is, Lordship, they have stated in the order, but in reality, there
See,
is no
again,
framing
Madam,
of that's why I'm saying, Lordship. And another second thing is, I admitted that, of course, that specific pleading was not there. However, Your Lordship, they have stated just now, Lordship has pointed out how many issue has been framed. But because the issue framing means there should be a suggested issue framed by the court, and after that there will be a evidence, and the issue has to be discussed in
You
detail.
understand, Mr. Sangma, you have
Lordship,
said all
those things were
submission.
not there, Lordship.
You made all those submission before also. No use of repeating it again.
Lordship.
The problem here is that your writ petition, the order appended in your writ petition says that issues are specifically framed. Now you want to controvert it. Now if you want to controvert anything which is recorded in a judicial order, there has to be a specific plea taken by you. Where is that plea?
That's why I'm saying that I have admitted. That's why there is a defect in my petition. That's why I'm saying
This
that.
case was filed in 2018. After 6 years, can you be allowed with liberty? You can withdraw it. But then the problem is with liberty. Mr. Mahota has objection.
No, Lordship, because it can be happened because just it should be given opportunity. If there is a defect. Only problem is if there is defect.
See, there is a time for detection defect. Doesn't mean that at the hearing when you find this is your weakness, you say this is a defect, please allow me to do it. And apart from those two things, what has been pointed out by Mr. Mohanto on the other day also, you have made a prayer for giving effect to certain order which has already stood set aside by this court. So how can you make this prayer?
Apart from that, your Lordship, another prayer also there. There's only amount given by the High Court's order. Second time when they came. Again, I don't understand where this is going here. This is the third litigation, third time.
If you commit
Third
wrong,
time
it is
litigation is because it's coming from the lower court, and there is a court order that twice the court has remanded, and after the trial court, then again come back to this court.
Sir, what are the issues framed?
My lord, I have asked for the order sheet, my lord. They have sent me the order sheet. Probably the entire record they have not sent me. The order sheet is there, my lord. The order sheet speaks volume, my lord. And moreover, my lord, suggested issue of his, my lord, he has enclosed, my lord, of both the parties.
He may have given suggested issue, but it doesn't mean that the issues were framed.
No, my lord, the order sheet says, my lord. If my lord give me some time, my lord, I will ask them to send me the entire record, my lord.
That is better one way. At least that will cure the attack. Since you are opposing to his prayer for withdrawal with the liberty.
My lord, the issues was framed on 17/12/2014. Both parties are present and represented. Both the parties has filed their suggested issues, and issues are accordingly framed.
That is what this court has seen. Page 120.
Thereafter,
What order did?
2015 High Court's order is. That's why I want. After all this thing, when the court passed this, as per the RD order of the High Court to follow, they again came to High Court. At that time, his counsellors said that no, the district council record will speak. So let it be sent by the district council record. Then court again send it. I have the order. He enclosed the order. Election 18. If your lawsuit is
Page.
Annexure 18.
uh,
Annexure 18 is page 144, my lord.
144.
44.
See, there are
147, the relevant page. my lord.
147.
Fourth paragraph, my lord.
Lawsuit is to say, what so 26/8/2016.
just
Sir, issued by P.G. Samuel, London Council for on behalf of the petitioner was
this order by order on 215, WPC number 215.
215, yes, my lord.
2016.
Yes.
So issues problem came out in 2014. Then thereafter they have come in 2016. Then what happened? Honorable High Court ordered is 27/5/2013 passed in WPC. So the respondent, in violation of the state judgment, adopted a different method.
This was a writ appeal or what?
No, my lord, this is writ petition, my lord.
Then what is this? Is writ appeal is allowed down below? Page 147. With this observation or direction, this writ appeal is allowed.
Oh, yeah, that is some typographical error. Yes, yes.
Because they said London Council further considered that the records of the asking land in question is available in the office of the district council. So they have to decide the matter on the basis of the records available in the office.
That is okay. No, but then what you are trying to point out from this order?
What I am trying to point out that your lordship will come to next prior to that page, answer 16 and 17.
NHS 16 or 17. What page? What is
Answer
it?
16, your lordship will see.
Page?
Page 135.
135, your lordship.
Give some space to search.
So, date of judgment and order date 2/6/2015.
Yes.
But both the parties lawyer for the opposition object the continuance of the present proceeding in view of the order date 15/3/2000 to pass in revision after appeal number 13 of AC of 2010. The learned lawyer of the petitioner has drawn my attention to the order date 27/5/2000 passed by the Honorable High Court of Meghalaya so Sama and others, including the present OP, in this case, the High Court has clearly set aside the order dated 22/10/2009 passed by EM in church, and also the order dated 15/3/2013 passed by CM DHHC in April 2022. The opposing party has erroneous mentioned the order dated 15/3/2013 as order dated 15/2/2013. The Honorable High Court has further directed in the same order that the EM in church DHHC shall decide the respective claim of the parties appraised after giving full opportunity for putting up their respective case. In view of the above order, which is not ambiguous, by no merits in the submission of the learned counsel for the office, the case will proceed as per the direction of the Honorable High Court.
Yes.
And thereafter, your
They have gone to appeal, my lord, against this order.
This anyway, and that is how. That is
no,
how.
No, I'm coming into that. Now your lordship will come to the prayer portion. Prayer portion will come. Obviously, prayer portion. The first prayer it comes. Following up with the response to so-calls at page 27.
Mr. Mohante, we'll come back. We have to go and see the division magistrate. Cannot make. Will
See what is it. इधर आइए, आप आ जाइए, आपका हाथ।
Lordship, that page 27, the prayer portion, I just wanted to show your Lordship that when it said that SOCO says to why the regional national manual certificate should not be issued, to say the Senate caused the impugned order date 2/6/2015, that NHS 16. In so passed by the executive in so Tura, and the judgment and order dated 14/6/2016. That is also by CM. So both these two order has been culminated in Annex 18 before the High Court. There's a second round of litigation. Then High Court sent them, that time they say that it will decide by the records. So issue chapter were closed at the time.
And then what is the main challenge here in this? What is
Then
the,
here,
what is the order?
these two order that has gone much. And the last he said an earlier order which said that also his challenge. That to gone. Now remain only the order of this challenge, your Lordship, 28/12/2017 by the EM inches and 12/10/2018. Only these two order left. These two order left. And in this petition, your Lordship
Earlier remand was to whom? To the EM?
EM inches.
Okay. So that means the order dated 12/10 is passed by EM.
EM.
And then
No, 12/10 is passed by CM. 28/12/2017 passed by EM.
okay, yes.
That is under challenge now, and this only these two order under challenge in this present. So, plus your Lordship will see from page 144 to the end, these are repetition in the petition. These are nothing, these are just repetition of the annexes. 144 to the end. This is all repetition of the earlier annexes.
Anyway, this is
That so means I don't want your Lordship to burden those pages. So now main purpose is your Lordship that first EM inches order, that EM order, your Lordship, that is the most important thing. That comes at 28/12/2017. That is at page 149. The relevant part start from 151.
just told Mr. Mahato. I think Mr. Sangma has not finished. I think
As
let him
your
finish.
Lordship, as your Lordship.
You have not finished, isn't it?
Lordship.
You are probably you are yet to start your argument, isn't it?
Yes.
Except for replying those specific issues.
Yes.
So I think let him place. You see, like
Yes, yes.
just do not demolish him.
No, it's not that.
create
It's,
something.
it's not that. Because since Lordship is making few queries, therefore I just want to make it cut short that only we have to
So
confine
you
this.
are saying those two orders are not in existence. So
No,
there is
not
question
it.
of
I said that
intervening.
prayer, those prayer cannot be looked into.
So
Your
only what remains is to see whether this order dated 28
12, 2017
and 12/10/2018
and
Just in
10,
accordance with
12,
law.
12, 10, this two order.
whether these orders are valid or not.
Well,
That is what is.
only that.
Now just wait
whether-
to see what are the grounds here. Is.
Yes, that's what.
Lordship, I will just file my written argument and then we will place it because I will prepare the next date. Now, the written argument which the hearing is like a part heart only. I am not taking time.
Issues are small. Why written argument is
Not issues actually, according to me, it's not small. The first thing is, Lordship, what I'm trying to, the crack of the case. First, where the agriculture account has been cancelled without issuing the notice to me, because there are so many. After that, there was series of different order passed by the EM, CM, and the High Court going back. But the crack of the issue here is that since the particular agriculture has been in existence since from time immemorial, but only in the year of 2009, where I actually read, they have cancelled without issuing notice, and there is no application by the parties on what basis the order has been passed cancelling by agricultural account.
That was the initial.
That was the
But then
initial.
subsequently you approached High Court. isn't it?
Subsequently, there
The
were.
matter was remanded and then I think you were hard, isn't it?
Now I'm saying, of course, as I have admitted in the flagging, of course, that procedure, the basic principle procedure, in all the hearings at the trial court were never followed. That I shall point out in the case of Dorisama case.
Tell us, you specify it. What are those procedures?
The procedure
And which-
actually that's supposed to be they file a deposition. Means like when recording the statement of the witnesses. While recording the witness deposition of witness, there are two. Lordship is very much aware. There are two things.
This court is not at all able.
You know,
You have to tell us.
no, what I'm trying to say is the procedure. What I'm trying to submit is when the evidence is left, when the statement of the evidence is recorded, either they are allowed to file a deposition on the basis of the deposition, they will record the statement, or they will call.
Recording of evidence
Yes,
before the EM or CEM
yes.
would be guided by what provision of law? Whether evidence will have evidence.
It will be guided by the provision of CPC.
Where CPC is lays down the manner and mode of recording evidence. What provision?
No, but there is a procedure, Lordship, because the recording of
Procedure, you just tell us. You say what are the procedures and how those procedures are not followed.
but the fact is they will not. But there in the trial, that recording of the statement is the must. They should have record the statement of the
That
witnesses.
is where it is provided.
It is provided in the judgment of the procedure that the Dorisama case in that.
Where is that? We are holding Dorisam.
Yes, it is in the
Relevant part.
para 20.
Does it make recording of evidence compulsory, or it says that it can be or may be? What
Para
is the-
20.
What is the relevant paragraph?
Para 20, my lord.
There are
20.
20. Yes.
For all this reason, we would hold that the revenue member alone has the jurisdiction to decide the type of dispute
At hand.
dispute
At hand.
at hand. But then, while doing so, the revenue member has to follow the fundamental principle of judicial procedure. Case being framing of issues which has been regarded as necessary for court to get the grip of the case, and this C video, this and this versus GRL, so and so. Secondly, second opportunity to lead the evidence on the issue frame. The evidence given could be recorded in full, or summary of the same could be noted, and hearing of the parties themselves, all through their lawyers engaged. This apart, some other accepted principle of
Sound
judicial
procedure, yes.
procedure, like not allowing a document to be used in a case without the other side having been given an opportunity to rebut the same, should also be followed when the case is taken up by the revenue member in the first instance by the chief executive member on appeal.
Yes.
So I'm saying that there.
Now, you want to say that no opportunity was given to you for reading evidence?
I'm saying that this principle was not followed.
See, whether evidence recorded and not recorded may not be a fatal to a proceeding until and unless there is something to show that a party wanted to adduce evidence and said it was denied. Okay. Now, if you want to say that the authorities below have not given you opportunity to adduce evidence, then definitely so. But then if it comes to that you have never asked for it, or that situation did not arise, then how?
No.
There's a
Here
violation of
also,
procedures.
Yeah, I mean, denying also. They have not given an
Where
opportunity.
is the specific statement that you have been denied? Tell us by what you have prayed, on which date you have prayed for recording of evidence, and on which date it was denied.
Your Lordship,
To show us that no opportunity was provided, you have to establish it, isn't it? Otherwise, whatever orders you have appended with your writ petition, it says something else. That opportunities were given, issues were framed, those have been recorded.
is
To dislodge it, you must bring some materials on record. What are those materials?
no, I'm saying though it is on the order sheet, it is recorded, but then practically it is not there. You have not
You have
practically.
not made any statement in your writ petition. See, whatever has been produced from the record goes against you. Now, if you say that there is a specific plea by you, you have to support it. Okay. Now, okay, we understand that you have not taken a specific plea in your writ petition. Only you have made a general statement that procedures were not. Now, to pinpoint what are the procedures which were not followed, please take us there.
Yes, because they're saying because the framing issue was there, but that framing of issue there is no findings.
Okay, we'll just record your thing because this is ultimately you're repeating the same thing. So your first ground is that no issues were framed.
Lordship,
Is it correct?
Lordship, no issue is framed, and there is no finding,
Definitely, if there is no issue framed, definitely. So that is
no statement of witnesses were recorded.
you want to say a recording of statement is mandatory.
Lordship,
It's
mandatory.
basing on those propositions.
Lordship. And no opportunity for adducing the document was not given.
No opportunity for reducing
The document.
documentary evidence. Isn't
Document.
it?
Therefore, I'm saying that the principle will not follow by the learned trial court, by the EM.
So these are the main principal ground for challenging the impugn orders.
Lordship.
Okay.
That is, yes.
So there is no specific thing for you to show, project that. Have you ever made any prayer?
Yes,
to the court?
I as I said, I have not made a specific.
You have not made. Forget about writ
Lordship.
petition. That part is over.
Yes.
Now, is there anything to show that you made a prayer before the authority concerned to adduce evidence?
It is not in
you
the,
have
at the trial court, Your Lordship. It is not mandatory on the part of the lawyer to ask for this. It is,
So that is a normal procedure.
yes.
And then how
It is the court to.
how the concerned authority will know whether there is evidence to be adduced or not? Did you file any list of witness?
No, it is the court should
The court should also file list of witness. on your
I'm
behalf.
not saying. It is a court to follow those procedures without being insisted by the
So
advocate.
if you do not give a list of witness, it is the court duty to ask.
Lordship.
Okay. And what else?
And
Did you file any list of witness? No.
that I'm not aware.
Okay.
Yeah,
You do not know.
No.
Mister, you are arguing a case after so and so. Acha. Then you tell us what are the documents you wanted to exhibit, which you are not allowed.
Map, my lord, the
Yes.
Adugachorak map. As per the according to the petitioner, there are 3 maps,
So one map you wanted to do, and then
but it seems that
map prepared by you.
no map was
Prepared by
which is on record, Your Lordship. This
Okay.
the prepared by the JHTC. and that map they have not considered. I
What
have
else? What else?
a map and a boundary
Boundary.
of the
So
agricultural.
that is projected in the map, isn't it?
Yes, because even in the map also I have even enclosed in my annexure. There are three
It's okay,
different
it's okay.
maps.
Now tell us when you wanted to produce it before the before the EM or CM as a case.
That they wanted to they wanted to produce before the in the court of EM.
When you tried to do it and by which order it was refused?
No, actually, the opportunity was not given. That's why those things
So
were
that
not.
means you want to say basically it is a court duty, not your duty to produce. The court has never told you to produce, isn't it?
No.
So that's why you have not produced. It is not a case that you wanted to produce, the court refused.
Lordship.
You wanted to produce.
You wanted to
When
show.
that is then tell us when you wanted to produce and how. You filed a list of documents.
The list of document, Lordship, let's see, they have asked for it. Otherwise, in the petition,
Any statement in your writ petition that you wanted to file any document?
Lordship, those amendment have not made, your Lordship, in this one.
Okay. That is enough then.
Yes, in the page 166 in the pleading before the
Page
chief executive member, that prayer was there
166 of
in
your
the petition, which I have enclosed. That whole petition, my pleading before the CEM of GHATC. We have narrated
page 166.
page one. May I start? It start
wait,
from
wait,
164
just a
till
minute, just hold on. Let us come. Yeah,
page 21.
just a minute. Just,
Annexure no, not page 21. Annexure 21, page 164.
how many of page 150 you have, Mister?
No, 164. 164.
No, that is okay. But then there seems to be pagination of 150, 151. These are double there.
Isn't two double mill?
No, even pagination also. This will create problem. There are two page 150 here, which this court is holding. These are the same documents, marked twice or what? One
There is
marked
some
as
document
Annexure
which
19.
we have just repeated because that document which they have enclosed in
Not only
the.
repeated, you have repeated the pagination also. Yes. What is the page number?
164, my lord. Because this copy we have taken from the court only because there is, in order to avoid some confusion last time. $164.
Very difficult if there are double pagination. That is a problem. Yes.
Yes.
This
This
is
is
an
my
appeal.
pleading.
This is an appeal.
Yes, the 164 to till 167.
Okay. And what is our relevant part you want to show?
I may I read your lordship after from para 3 till 7 as well. May I read your lordship from? I will read it just from para 2.
The entire petition.
Some I will read
Show us
it.
the relevant part. Because you see, some documents are annexed with your petition, isn't it? Photocopy of annexure 1, certificate copy of
Because
order. Photocopy
according
of
to me,
annexure
this even the para 4, and then the
Therefore, what do you say?
during the process of hearing the appeal, this court authority was pleaded to direct the concerned Majunda to conduct a press sport inquiry, and the Majunda submitted that his inquiry report dated 30/04/12 with allegation by the concerned Majunda that Mujada, the respondent, and her men assaulted him and in human way tortured him to make favorable report to this authority. The appellant also submitted that the document before this authority in which the Majunda concerned alleged that he was also subjected to interference by the present respondent and her supporter during the process of sport inquiry and submission of report during the trial of GHADC revenue number 101 AC of 2009.
Yes.
Here, what they're trying to say is because even when the Majumdar have gone for the inquiry, the opposite party,
You
they,
refer to a report dated 34/2012, isn't it?
Lordship,
Now, this is your statement, isn't it?
before the
Okay, so you do not have that copy of that report.
copy of the report was not furnished to us.
No, what is your case? Whether you wanted to produce this copy, the court did not allow you, something like that.
No, my submission here is this, Lordship. When the Majumdar have gone for the inquiry,
No, Mr. Sangma, just let us
Lordship.
not get diverted.
yes,
Just tell us, we are on the
Yes.
point of document. That you wanted to say that you wanted to exhibit
Yes.
some documents
yes,
which are not allowed.
that even
We are trying to determine where are those.
that report was somewhere I have enclosed. But yes, I'm saying that
We
even
will not
those
decide whether these documents are relevant or not. This is not our one.
yes,
We'll only just would like to see that you wanted to
yes,
exhibit some documents and this is not allowed.
Court
If you
have
can
not.
establish, then definitely you have a case.
yes.
Show us what are those documents you wanted to exhibit, and it was refused. Because Doresami say that you should allow the documents to be produced. Is okay.
Yes.
Now it seems in your petition you have appended quite some documents with it. Court did not say that we will not accept with it documents, isn't it? So some documents you have brought in. Then what are the documents which
Document of the Majumdar report and also the letter of the Majumdar,
tell us
then the map.
how you wanted to bring it. In your petition, why you have not enclosed it in your petition? You have referred it.
Majumdar report, Lordship, it is there, Lordship.
So you have annexed it.
Yes.
So it means documents are allowed then. That means your
No,
content is not correct.
not there, but in that petition somewhere it is there.
You are not very sure. You see, you are changing your stance every now and then. Stick to one thing. You say that documents, you wanted to exhibit some document or produce some document. This was not allowed. The simple question is that what are the documents and which date you wanted to produce it and when it was written.
Lordship, I will prepare the written argument specifically because
Not required written argument, but then if you want to give us the date, gist of this, okay? Give
so
it gist of it.
I prepared
But it has
the
to be, it
Yes.
has to be this thing. We will not entertain you
Lordship.
to file a written argument by which you bring in certain
No,
points.
no.
And later on you say
Because
that
I will be giving my written document, but I will just point out the list of date, the correct list of date, and prepare and
when you can supply it
after 1 week I can submit, Your Lordship.
after 1 week. You give him 1 week time. Let him give it.
See, Your Lordship, what document he is saying, if Your Lordship permits me, that culminated in the High Court's order of 2013.
Yes.
All those things EM Inches has taken care of. They came here. Then thereafter it has come to status that all the orders. EM Inches
Court
order
order
and CM
only
Inches
says-
order on the basis of all those documents. Whatever the case.
Go by the document, but when they were speaking, they have not specified.
No,
they
you
also
can
have not
reopen
specified
that.
any document.
We will just confine ourselves what happened after
Yes.
the remand.
Yes, after that's all.
Okay.
Because this is a
That is
point
what.
to that.
Okay. Now, even then, the opportunity to produce
that's
documents
obvious.
was available with him even after the remand.
That's
Now, this court query will be confined to that after
Yes.
the remand,
as you also.
he wanted to produce some document and the authority below
Yes,
had not allowed.
did not allow.
That is what.
As you also.
That is what. Will not go beyond that.
Because why?
It's a read court cannot go into the
Yes,
merits.
because those are already gone into that. Set aside those all.
Hard. Under counsel, depending on the parties. Petition, no? Direct counsel for appearing for the petitioner submits that he intends to file. Gist of your argument.
Yes, Lordship. This is argument along with the debt.
You want to file a gist of argument with chronological list of the argument.
Chronological date.
Mr. Pretty Sangma, learned counsel submitted that he desires to, he may be allowed to file a written gist of his argument with list of chronological date and events.
Lordship.
We started as he intends or he prays. Okay. Then you say then and then after the sentence and prays for grant of
2 weeks, my lord.
2 weeks will too long. This court will forget. The problem
No,
is
will
that
not forget because it will be recorded, my lord. The last order, Lordship, because when it is reflected, even the court can just see the order. Then I cannot lie to the court to any party also. It will because it will be reflected in the court order. So there is no question of forgetting.
In the other court yesterday, my
on the last date you created the ground for him.
Yes.
You wanted him.
yes, because my lord,
So-
what he was saying, my lord, is otherwise with the record, my lord. When we examine the record, my lord, he said otherwise, and he
No, no,
doesn't
no.
submit as per the record, my lord.
No.
He goes beyond his imagination, my lord.
Not
Now,
going,
now, my
I'm
lord-
speaking from the record only. Just now, which I have read it, it is not 10 days. He's out of record.
Just allow, let us. Just we are on the
Yes.
issue whether it should be 1 week or 2.
Yes, only on that.
1 week, my lord, so that and in advance let him give us the copy, my lord. We'll reply to it on the next day.
Because
Yes,
I
he's
have
thorough with the
so many
subject.
other things also. Because 1 week, because ample time should be given, no? So that I can prepare where. Because it's in every case is very serious. I cannot simply just do it anyhow. Because sufficient time should be given,
Okay, we'll give it 10 days.
Lordship.
Hopefully, you will not say his computer got spoiled last
No,
yesterday.
no.
He made a submission, my
No,
lord.
that was what not.
Submission.
Whatever
what
submission
person
make,
has to-
other side he cannot make it
Let us
submission here.
Limit with
What?
a certain limit.
Yes.
Let us not travel beyond that.
What happened? Other court? How can he make a
Just
make a
confined to
submission
the
here?
course and power of. See, there should be a limit for us.
Yes.
Anyway, where we can see. No, do not say submit. Oh, yeah, submits that. Submits that. With written decision with chronological dates of event
Lordship.
or by mentioning chronological date of event and praise for grant of. Will not record your objection. Shall we say? You are not objecting to the filing of it, only to the time of it. Just say prayer aloud. The Lord Council petitioner is granted 10 days time to do the need.
Lordship.
list thereafter.
Well, I have a small player, my lord. Let him give us in advance, my lord, a copy. We'll be prepared, my lord, on that.
Before, what you said, learning council is given to do the needful. No, do the needful.
By giving advance copy to the court.
The petitioner shall also supply a copy of the gist, the gist of written argument prepared by him to the other side before the matter is taken up next.
Lordship.
Then down below say list accordingly. Yes.
Most Venerable Lordship.
Item number 7.
Yes.
May I please your lordship? My lord, this case pertains to the land acquisition for setting up of the Balpakram National Park, my lord. And my lord has posed me a question on the last date. I'll just on the 9th of April. And
Question was put last year or this year?
my lord, it was this year.
Can you just tell us
9th of April, my lord. So the question that my lord has put me was that can the writ court, my lord, can the writ court bypass the statutory provisions to give a relief, my lord? And I've researched on that, my lord, and yes, under what circumstances, my lord? Yes, under extraordinary circumstances, my lord. And this writ court is itself is a court of extraordinary jurisdiction, having an extraordinary
provided there is
jurisdiction.
existence of extraordinary.
Yes, my lord. Yes, that I need to just demonstrate to my lord. Here, my lord. So I will just like to submit the judgments, my lord.
You come to the facts, Mister. You've been fast. You see, like otherwise this.
My lord, the facts. So, my lord, here the facts is this: in the year 1985-86, my lord, 1985-86, the government acquired about 220 square kilometers, my lord, from 10 kings, my lord. And by paying, my lord, 3.63 crores, my lord, 3.36 crores, my lord. That was first. And again now, my lord, in the year 1991-92, my lord, in the second phase, my lord, about 76.25 square kilometer was acquired. That was the second phase, my lord, and at the rate of rupees 1.26 crore, my lord, and that would work out to, my lord, 1.65 lakhs per square kilometer, my lord. And also, my lord, in the year 1994, the third phase was acquired, my lord, of about 15.5 square kilometer for an amount of rupees 25.69 lakhs, my lord. And likewise, my lord, in the year 1995 also, 39.91 square kilometer was acquired, my lord. The rate that was paid, my lord, was only 1.65 lakhs per square kilometer, my lord.
By this petition, you are seeking enhancement of this rate.
By this petition, my lord, what we were saying is, my lord, the amount that has been paid, my lord, it is not adequate, and in a way.
So you did not follow the procedure prescribed by Land Acquisition Act. Section 18 and all did not come. When the rate was prescribed, we did not receive it under objection.
That is the point, my lord. That is the point of where the dispute arises, my lord. Because why I said is, the people who were paid the compensation, the Nokmas, my lord. The Nokmas were the rustic villagers, my lord. Rustic villagers. Now the law says that it is the paramount it is a bounded duty upon to the authorities to inform the villagers that you also have the right to receive on protest. No, that is an established procedure, my lord. Now, now the government in this petition, when I've come before my lord, the government, the respondents are more interested to dismiss my case on technical. Of course, one case before the Guwahati High Court and the Shillong bench have dismissed one of my matter, closed my matter rather, on technical. The merits of the case were never heard, my lord. Merits of the case were never heard. And the merit of the case and the facts remained that the gullible villager, the rustic villagers, were lowly played. We have given our tutel of more than 300 square kilometers of our land, my lord. And for what? For the interest of the nation, for setting up of a national park, my lord. And in return of that, what did we get? In return to that, we were underpaid, my lord, and was not even informed. Therefore, my lord, my pleading is very clear. I said that in paragraph 3 of my pleading, I said that these are the villagers who were not aware of the rights. And further, I went to say, my lord, in the next paragraph, as saying that the procedure established under the Land Acquisition Act was also not followed, my lord. And if it is not followed, my lord, I would take this opportunity to
When
say
this acquisition took place, when the last phase?
the last phase of the acquisition took place in the year 1995, my lord.
You are,
1995.
is it not barred by delay?
I'm sorry?
Is it not barred by delay?
It is not barred by
You approved in
delimitation.
2019 only.
The government, my lord, the law, the opinion of the government, my lord, the deputy commissioner, who is supposed to, who is the concerned authority, my lord, himself says limitation limitation does not come to play,
He's saying will not have any bearing on the question of law,
my lord,
whether it is barred by principle of delay or not.
my lord.
Will not go by what he says.
My lord, therefore, my lord, what I say is now, my lord, there is an occasion where my learned friend's case was there, my lord, in the case of the Winkle Star Karmolong also, my lord. Mr. Sen, it's your uncle's case, Mr. Sen. Okay. SN. So this case also, my lord, where the enhancement, in this case, what happened, my lord? This case, they have accepted the full amount, but the determined amount was something else, which were lowly paid, my lord. The single bench allowed the enhancement of the amount to the landowners, my lord. This was for the purpose of setting up a forest only in Pet Benang, my lord.
Enhancement was allowed by the single bench.
Yes, yes.
But then there was no proceedings under Section 18 of the Land Acquisition Act.
In that petition also, my lord, the plea was that the land acquisition proceeding has not taken place. It was paid on the basis of agreement only, my lord. It was paid on the basis of agreement
so the
only.
Taking over of land was not in pursuant to the role of any proceeding.
It was not.
It was a kind of a donation of land and acceptance.
It was by way of an agreement, my lord. And in that agreement, my lord, they have agreed to pay 18 point some rupees, my lord.
Say supposing.
I'm sorry.
If any land is taken over.
Yes.
In pursuant to
an agreement.
Okay. Then yes. Whether any acquisition is required to be drawn by invoking the provisions of Land Acquisition Act. My lord, of course, my lord. It has to be drawn, my lord, because that's an act. For otherwise, the entire you agree to everything. Yes. To hand over the land. Yes. On payment of certain amount. Yes. Yes. And on that basis, handing over and taking over. Yes. Takes place. Yes. And the payment is made. Yes. Will there be any illegality? Now, so far as this part of the land is concerned, yes. You may say that the transaction will be hit by the provisions of land transfer. Yes. But then government can always exempt.
No, that is
Okay.
true, my lord.
So
Yes,
supposing, let us say, just it is on assumption,
yes,
just to understand the situation, you see, that the government grants exemption and the
Yes.
transaction takes place. Now, where the Land Transfer Act will come into operation?
No, my lord. Land transfer act, if the government, my lord, under section 3 or section 7 of the Meghalaya Land Transfer Act,
No,
the
no, we are not,
Regulations Act.
Meghalaya Prohibition of Land Transfer Act, no, we are
Oh,
not showing it. We are talking about this whether Land Acquisition Act will come
yes,
into operation or not.
my lord.
Maybe
Land
the court has uttered wrongly.
it has
We-
to. My lord, now what happens? Let's put one situations, my lord, where we have done with the Maupalai forest, my lord. There was a departmental committee, my lord. Now this interdepartmental committee, what they did is they identify a plot of land, and when they have identified a plot of land which is suitable for afforestation, they have to discuss with the villagers, my lord. Now there comes a negotiation with the villagers. Okay, we take up this one, and we will be paying you this certain amount. Agreement is done. Now, my lord, once the agreement is done, they have to come back and resort to the Land Acquisition Act, my lord. Notice has to be given. Of course, that would amount to a formalities, my lord, but you cannot bypass the act, my lord, just because you have agreed, my lord. You cannot bypass.
So it means you want to say a private individual
Yes,
cannot donate a piece of land to the government,
but donation is something else.
or rather
Donation is-
cannot transfer it by way of sale.
My lord, the acquisition, donation, and sale, these are all totally different
Definitely,
things, my
that
lord.
is what. That is why precisely this court is asking you,
Yes,
when any transfer takes place
yes,
in pursuant to an agreement,
yes.
whether that will be hit by the provisions of Land Acquisition Act.
My lord,
That
then,
transaction will be hit by the provision of Land Acquisition Act.
my lord, but the situation may arise there, my lord. If simpliciter, it is a transfer or it's a gift or it's a lease to the government, then, my lord, land acquisition may
It's
not
not coming into
is
picture.
not coming into picture.
And then at what
But
situation?
oh, but then, my lord, by the situation may arise that the government says that we will acquire your land for certain amount. Then, my lord,
Definitely, that is
they may come.
understood. You see,
Yes,
that is understood.
yes, my lord.
That is the law. Law is there for it, so
Yes.
that the government cannot just go and take your
Yes,
land.
yes, my lord.
That is why these provisions were prescribed in the old
Yes.
Act under Section 4, Section
Section
6,
section
Section
6,
9,
section
Section
9,
11.
and
All those you have to follow.
yes, my lord. Yes, yes,
That is what.
yes.
But then these provisions would not apply when transfer in pursuant to an agreement comes, where both the parties agree and the transaction is not hit by or is not barred by operation of any law.
My lord. That is, my lord, in this judgment, my lord, it says something else, my lord, and that in the in
This
the
judgment
case
where
of Winkle Sir
Mr.
Karmalong,
Shan had appeared.
his
He
uncle.
will be able to tell us
Mr.
something
Subir
more.
Mr. Subir sir. Wait.
So, my lord, coming back to my case, my lord, this I'll submit a judgment.
This judgment speaks about what? This one was what subject?
My lord, this subject is also about a land compensation, my lord.
This is enhancement is sought on,
My lord, what
on
had
what
happened?
contention, on what basis?
My lord, may I just very quickly read this one? It was. It's not a very long judgment, my lord. May I?
You do not have to read it. The only thing is that you just tell us whether this enhancement is sought in a proceeding which was initiated under the Land Acquisition Act. Or it
Yes,
is-
yes, yes. It
Okay.
was. Yes, it was.
And then there was no this thing,
I'm sorry.
no proceedings under Section 18 and all.
Yes, yes. It was not followed, my lord.
But even in spite of it was not followed.
It was not followed, my lord. It was not followed.
And then High Court, the writ petition enhanced the rate.
Yes, yes, my lord. So this is the case. Division, single bench. We want a single bench.
There is a High Court which has assessed the rate and it has enhanced.
No, no. The amount was already agreed, my lord. because when the landowners were
That is
paid,
an altogether
yes,
different situation.
yes, yes,
Not applicable here in this case.
yeah.
Anyway, this case also, this court is yet to get the advantage. Okay.
Yes.
Now here is let us come back to this.
Yes.
Things. Probably you are getting diverted to something else.
Yes. So now, my lord, when we come back to here, what happened? What I was saying is, my lord, because this is the point that the respondents have taken. This is the point where they have raised an issue, my lord, of maintainability. Now, my lord, there I will just draw, my lord, to page 36, my lord, page 36
Of your writ petition.
of the writ petition, my lord.
Yes. Now here, just what is the fact that land were
Yes.
acquired in 3 phases,
Yes,
and the members of your association they are affected.
yes, because
And
we
the
are
last phase of acquisition took place in 1995.
1995, my lord.
Then some amount of money was paid to you.
Yes, paid to the
Then you
association.
are not satisfied with the rate.
We are not satisfied with the rate, my
Then
lord.
at that point of time, you could not file any application because you are ignorant of law.
Ignorant of law. This is what
And-
we are saying. Yes, my lord.
And then matter just
And then also, my lord, we were not also informed of our rights to file, to receive under protest, or to file and to move an application for enhancement or section 18 of the act, my lord. We were also not informed, my lord. So therefore, it went on, my lord.
the section 18 is the work of the collector. That is not your work. You will just only make your objection.
Objection,
The
my lord.
remaining of the thing will be followed by the collector.
Yes, my lord. Oh, yes, exactly, my lord. Yes.
So, here, but then it happened in 1995.
1995.
What took you so long to come to court now?
My lord, no.
How suddenly you have become aware of your right now?
My lord, no. In between, my lord, in between also, my lord, before coming to this honorable court, my lord, in between there was also continuous fight, my lord. Continuous fight. But as I said, my lord, it was dismissed on.
Fight means fight where?
It was
You are
fight
not
before the
referring to
Guwahati High
physical
Court.
fight, isn't it?
No, my lord. It was. I mean to say the Nokmas were not sleeping over their rights. They were continuously pursuing their remedies before
way?
approaching by way of filing a writ petition, my lord.
Achha, the earlier also writ petition was
Yes,
filed.
earlier writ petition was filed. Yes.
Raising the same issue? Raising the same issue which you have raised here?
Raising, my lord, that is what has this is the objection taken by the government, my lord. Therefore, if my lord recollects
do not
my
come to what the government say. They will say what is this?
yes, if
Just
my
tell us
yes.
the facts,
Yes.
uncontroverted fact.
yes, my lord. So, my lord,
You filed a writ petition before.
yes, we filed a writ
And then
petition
the
before.
writ petition, there also you have prayed for enhancement of rate.
We have prayed for enhancement of
And
the
then what
rate.
happened to-
We agitated. We agitated, saying that this was we have been cheated. We have been cheated. Then the writ court at that point of time, my lord, has said that we have come. I'll just read, my lord. That will be what did the court says, my lord. My lord, page 18, paragraph number 3, my lord. We'll read from the above page 18 onwards, my lord. Page 18. Accordingly, my lord has got the point. Accordingly, 18 of the writ petition.
It starts with?
Under protest.
Yes.
Yeah, under protest, my lord. The paragraph 2 is just a fact of the case which I've just narrated, my lord. And my lord will come to accordingly. Moreover, accordingly, the word, my lord, second line. Second line. Yes. So according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by Garo Hills Autonomous District Council and paid them rupees 1.65 lakhs per square kilometer, which worked out to be a mere 200 per bigha. While determining the quantum of compensation, the value of standing tree crops, mineral deposits, etc. were not taken into consideration. Solution was also not paid, ignoring the provisions of the Act. Now, from own pleadings of the petitioner, it becomes
how Garo Hills Autonomous District Council fixes rate?
my lord.
How, under what authority, Mr. Chen? You
They
must
don't have
know.
any right.
He's not an authority under
And
the
that is their
land.
entire case.
No, my lord. My lord, at that point of time, my lord, this is the judgment which came is a subsequent. Is a subsequent matter where this court has said that the autonomous district councils are not an authority to assess the land rate. That is okay.
That goes without saying. The
That
provision,
goes-
provision
yes, yes,
itself
my
is
lord.
enough. It's a
Yes.
collector.
Yes. So my lord, mosquitoes.
Mosquito.
So we'll go to the next one, my lord. Now, from the own pleadings of the petitioner, it becomes obvious that the landowners represented by it are aggrieved by the quantum of compensation awarded to them between 91-92 and 95-96. In my opinion, it is now too late in a day to challenge the award made some 7 to 15 years before. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had the remedy under Section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within a period of limitation prescribed thereunder. Having not done so, the writ petition, insofar as 352 square kilometer is concerned, is barred by non-exhaustion of alternative statutory remedy. So, my lord, as for 11485 square kilometer of the Aking land, the state respondent at paragraph 11 of their affidavit of opposition dated 11/12/2002 have clearly stated that this additional land comprising of 8 Akings is yet to be acquired. This position is reiterated by them in paragraph 10 of their latest affidavit in opposition dated 18/8/2010. It also categorically asserted by them in paragraph 19 therein that the forest department does not occupy or use any of the
Of the aforesaid land.
of said land and will not so do until the same is properly acquired and handed over to them by the district collector. This is reaffirmed by the Chief Conservator of Forest, Government of Meghalaya, in his affidavit dated 10/9/2010. In the light of the categorical declaration made by the state respondent that they are yet to acquire the King land measuring 114.8 square kilometer, no mandamus can be issued by this court for directing them to pay the compensation. To this extent, the writ petition appears to be premature. It shall, however, be open to the petitioner to approach this court again if the state respondent decide to take over possession of the Aking land in question without paying of compensation or without following the procedures laid down by the Act. However, the state respondent shall not forcibly occupy or otherwise take possession of any portion of the Aking land measuring so and so before payment of the land or without authority of law ordered accordingly.
So now this present litigation is with regard to this 114.85.
No,
No, my lord.
This one, 352.
Is regarding to 352 square kilometer, my lord.
But
No.
it means like this order was appealed.
No.
This order was not appealed, my lord. This order was not appealed,
So finding recorded here, we can final.
Yes, Lord.
my lord.
What remains here?
No, my lord.
Exactly.
This finding here, my lord, this finding here is finding on the technicalities. What I'm saying is, it's not on the merit, my lord.
It's a bar created by law. That technicality bars. It creates a bar. So until and unless you come across that hurdle, we cannot go into merit.
My lord, my lord, my lord, now this chapter ends here. This chapter ends here, my lord.
352.
352, this chapter ends here. The ends here.
What chapter? 352 has how many chapters?
No, my lord. I mean to say that this one portion ends here, my lord. By the judgment of the Guwahati High Court, this matter
This
ends
is
here.
judgment by the Guwahati High Court. This is
Yes,
judgment by
yes,
Guwahati.
the Shillong bench there. Now, my lord, subsequent development. What happened, my lord? Subsequent development, my lord. We filed a representation to the government, my lord, because Guwahati High Court has never barred us for filing a representations, my lord. Filing a representation is our right, my lord. It has never barred us, my lord.
No question. Yes. Nobody can stop you from doing it.
Exactly, my lord. Now, when we file a representation, my lord, that representation was not disposed of. Therefore, this honorable court, my lord, therefore, this honorable court directed the government to dispose our representation by way of
By the same judgment.
yes, my lord.
By the same judgment. Where it is?
My lord, it is it's at page 63, my lord.
Page 60.
Page 63, my lord.
Same judgment.
No, not same judgment. There's another writ petition, my lord. That was this is the with regard to this 352, my lord. This would be the third writ petition, my lord. So the second one, my lord, is writ petition 500 of 2018. That is page 63, my lord. 63. Here, my lord, it says, heard learned counsel for the petitioner, Mr. So-and-so, who submits that the petitioner has filed representation dated 22nd May 2017, addressed to the respondent number 4, and pray the respondent number 4 may be directed to dispose of the representation. Respondent number 3 and 4 are hereby directed to dispose of the representation by a speaking order within 3 weeks. With this order, the writ petition stands disposed of. Now, my lord, I will take my lord to page.
What is your representation dated 22nd May 2017? What was that representation?
Representation, just show me the representation. I just come to the representation, my lord. My lord, the representations is 22nd, page 49, my lord. And this is not the first representation, my lord. A series of representation was
But
made.
the court order is confined to this representation.
Yes, page 49,
It
my
has
lord.
reference of many representations.
Yes.
And what is the prayer made in this representation?
The prayer made in this representation, my lord, is at page 52, my lord. Page 52
Yes.
is for reassessment of the land again, my lord. For reassessment, my lord. Reassessment of the land. Now, my lord, I will take one page 36, my lord. Before that, my lord, I will just come back to the previous years, my lord, of 2012, and I'll take my lord to page 36.
Now, just after the order passed by High Court
Yes, my lord.
to dispose of a representation, then what happened?
The representation was disposed of with a speaking order, my lord.
And then what did it say?
The speaking order says, the impugned speaking order says, my lord.
That granted you some relief.
No, my lord. Page 60. Page 60. Page 64 is the impugned order. Page 64 is the impugned order, my lord. Is a forwarding. And the order contains from page 65 onwards, my lord.
Yes.
And
It's a big order. Yes or no?
and the final finding is at page 67, my lord.
Yes.
Page 66, the last paragraph onwards, my lord.
Okay, it's all right. And now the last part is I do not find any section of law under which the petition of so and so can be entertained.
Yes,
So that means he did not get any relief.
we did not get any relief. Now, my lord, there is a two contrast and contradiction view, my lord, of the government themselves only, my lord. That is what I was trying to take back, my lord, to 2011.
View which supports the judicial order that will prevail. What is that? What is that view?
My lord, but both these views, my lord, are the views of the government, my lord. Page 36.
Shen is smiling.
It is his officer's report. One is at page 36, and another one is at page 64, which
Now, which creates a right in your favor?
36 creates a right in my favor, my lord.
36 is dated when? Which is
This is 17 August 2012, my lord.
36?
Yes, my lord.
And then 64 is 2019.
Is of 2019, my lord.
Then matter ends there.
I'm sorry, my lord.
then 2012
Yes.
will merge with 2019, isn't it? That is what the law is, isn't it? Huh?
Well, may I just read it?
Any order passed before
Yeah.
will merge with the final order, isn't it? And will stand modified to that extent which the final order says.
But my lord, I just need to submit something, my lord. Of course, my lord, what my lord has said that the merging of that part I've not been. But my lord, when that the merging happened, the merging will happen. But in the previous order, if you say that in consideration of the previous order, in this, my lord, there is in the
Tell us
2019.
what would be the law now? Why should we give primacy to that 2012 and not 2019?
My lord, these two, my lord, my lord, the facts of that is why I said, my lord, that there is a question that comes back now, my lord, when my lord has posed me all the law, all the statutory, of course, it is an undisputed fact. It is an undisputed fact that the villagers were underpaid. That is the undisputed fact, my lord. Now, my lord,
Undisputed fact, the state agree that they have.
where is their affidavit in opposition? All my contention, they have only tried to block me in my in technicality. In merits, my lord, merits, no affidavit in opposition. So how do we assume when all my contentions are
You
here,
have to first overcome the technical.
my lord?
The technical plea of limitation, you see, which bars you
Yes,
from approaching court
yes,
after a certain period of time,
yes,
or rather, we will say delay and latches, because Limitation Act will not apply in rape.
yes,
Okay. Now, which bars you from coming to court,
yes,
which is held by a court, and that order obtained finality. Where is the question of reagitating it?
my
Nobody
lord,
can reopen it now.
my lord, this is a new cause of the subsequent representations, subsequent order of the deputy commissioner, whereby he is saying that yes, the villagers were underpaid, they could have been paid more, they were underpaid. These are the all new cause of action which was not there, my lord, when the Guwahati High Court was deciding these matters. These materials were not before his
This fact
lordships.
remains
Yes,
that this pertains to the issue of enhancement of rate,
yes, my lord.
which is held to be time barred
Yes,
by a judicial order. So once that has been heard, no amount of executive interference can alter the judicial.
my lord. That is exactly why I have brought 3-4 judgments, my lord, where under an extraordinary circumstances, my lord can intervene, my lord.
What are those extraordinary circumstances, Mr. Even?
My lord, page 36 would create the extraordinary circumstance, my lord.
Just just give 2 minutes.
Yes, my lord.
One was the disposal of the writ petition, that writ petition by which it is held that claim is time barred.
2nd March 2011.
This order you did not challenge in appeal. No appeal was preferred.
No, this was not preferred, my lord.
So you tried your luck before the executive. Yes.
So after this order, my lord, page 36, my lord.
Yes.
Page 36, my lord.
Yes.
The Guwahati High Court's order was as noted at 2nd March 2011. At the next And my lord, there was one representation that was made on just a second, the fifth. There was some representations, my lord, from page 23, my lord. Page 23.
Yes.
Page 23, this is the representation of 5th April 2011, my lord.
After the disposal.
After, yes, my lord. And in this, my lord, we have asked, page 26, my lord. We have said in that, sir, para 7, I'm reading, my lord. That, sir, in view of the above facts and circumstances, it is crystal clear that the vested interest officers intentionally failed to carry out their duty in accordance with the laid down procedures, rules, and mandatory provisions of law in respect of payment of land acquisition to the Nokmas and the family members acquired by the state government. We therefore most humbly request you to kindly may look into the entire matter of land compensation paid to Nokmas, and further request you to influence your esteemed office for issuance of appropriate necessary instruction for concerned department to the tribal populace who would get the due share of land compensation and protect them from exploitation and atrocities, my lord. So this, then second representation comes, my lord, on 3rd of February 2012, my lord.
What
That's-
for you are referring all those things? You see,
No, my lord, this,
if a claim
Yes.
is barred by operation of law,
yes, my lord.
what
My lord-
purpose this contention will have?
No, my
Because you
lord-
are barred from raising it.
My lord, what I am trying to show by this
should have
is,
been ignored.
my lord, but the government has come out with a reply at page 36, my
That
lord.
also will not
All-
alter the position of law.
My lord, this is what created a new cause of action for me, my lord. This is what created a new cause of action.
You may say, but then in a disposed of matter, in a decided matter, where the principle of res judicata will apply, where is the question of creation of a first cause of action?
My lord, my lord, the question of res judicata, in my humble submission, in the humble understanding, will not apply, my lord. Why it will not apply, my lord? Why will not apply, my lord? Because while answering to my representations, the deputy commissioner has made a finding backed by some legal propositions, my lord, and has said and has affirmed, my lord, what I am also was agitating, my lord. Therefore, this would give a new cause of action. My lord, can I just read page 36, my lord? The rest are my representations.
You want to say the deputy commissioner section
Yes.
has the effect of reviving the cause.
Yes, my lord. This is what I wanted to impress upon my lord.
And it can overturn the finding record in judicial order.
No, my lord. The judicial order was on technicality, my lord. The finding of this deputy commissioner, my lord, answering to my representation was on fact, my lord, on the merits, my lord. Therefore, my lord, there is no question, in my humble understanding, there would be no res judicata, my lord. So, my lord,
And it's all right, no problem. You make your submission. What is it?
my lord. So, page 36, my lord, I will read this page 36, my lord. This is important for me.
Page 30?
36, my lord. That's annexure 7.
Yes.
Page 36, annexure 7, my lord. This is addressed from the Deputy Commissioner, South Garo Hills, Bagmara, my lord, to the Under Secretary to the Government of Meghalaya, Revenue and Disaster Management Department, Shillong. Subject: land acquisition in respect of BNP and matter relating to representation of the President / Secretary of Balpakram Aking Nokma Social Welfare Association. reference. So, in response to your above letters directing me to take action according to law in the matter, I have the honor to state that I have made an in-depth examination as to whether a reference to civil code can be made at this stage. In this regard, I have gone through: number 1, Civil Rule number 2016, decided by the Justice Dhiren Barua of Guwahati High Court, reported in JLR 1993, 1 SEC. This is the case in which the government of Meghalaya had acquired 5803 bighas of Aking land and paid rupees 100 and 200 per bigha to the landowners as compensation. The landowners had not accepted the award under protest. They approached the Honorable High Court for a reference under Section 18 of the LA Act. The High Court took the view that they are illiterate villagers and it cannot be expected that all those villagers should act in the manner the Act provides. It will be too much to expect that the Honorable Judge directed the Deputy Commissioner William Nagar to refer the case to civil court, and this was a decision of our own Honorable High Court. To my knowledge, till that the ruling has not been overruled yet. Hence, it is felt that we are bound by this ruling. A photocopy of the decision is. This is talking about the Dikman Sangma's case, my lord. Please. I'll provide, my lord, that one. Now, B, my lord, 37, my lord. B. A single bench of the decision of Punjab and the Haryana High Court disposed of on 21st May 2004, Faridabad Gas Power Project Limited versus Narendra Kumar and others. Photocopy. This decision also retaliates the principle laid down in the Guwahati decision cited above. In para 9 of the judgment, it states, there is another aspect of the matter. It is undisputed fact that landowners are illiterate villagers. It is well settled law that a person against whom a waiver is to be placed must be aware of his existing legal right. In the present case, the rustic villagers whose lands have been acquired cannot be expected to be aware of their legal right under the Act. It was the duty of the authorities to tell the landowners in unambiguous terms that they had a right to accept the compensation under protest and claim enhancement thereafter. In para 12 of the said judgment, it is observed in no uncertain terms that in such a situation, the landowners who are rustic villagers and had accepted the compensation without raising protest in writing cannot be said to have waived the right to seek a reference under Section 18 of the Act. The said rationale laid down in this decision is applicable with greater force to the Balpakram Nokmas, who at the time of acquisition of the land in question were residents of a most backward tract of Meghalaya, having a very, very poor percentage of literacy rate, less educational facilities, suffering from total lack of surface transportations, etc. And C also, my lord, AIR 1988, Himachal Pradesh, page 39, Division Bench, LA Act, petitioner are rustic villagers making application seeking a reference to court under Section 18, rejection of on ground that application was not maintainable since petitioner received compensation without protest not justified. Before the bar placed by the second proviso, the subsection 2 of Section 31 can be invoked against any person. It must be shown by acceptable evidence that he was aware of his right to make an application for reference under Section 18, that he knew also that such would be defeated if he accepted the compensation without protest, and that he nevertheless accepted the compensation voluntarily with it registering any protest, or his words or conduct were such that tantamounts to an intentional representation that he was accepting the compensation without any reservation. In the absence of proof of such facts and or circumstances, the court would be loath to place the bar of the second proviso to Section 2 of Section 31 in the way of the claimant. There is nothing on records relating to the accusation proceedings of in the Balpakram case to the state that Nokmas were either conscious of the right to protest or they were made aware of their rights. Gyan Singh versus Union of India, my lord, D. LA Act, object of law is to give what is due to one. There cannot be any fixed watertight litmus formula for refusal of a relief on the ground of because of delay in praying for a reference under Section 18 of the LA Act. The relief cannot be denied. On perusal of the above referred judicial pronouncements, it becomes crystal clear that there is no legal impediments for making a reference to civil court for reassessment of the total compensation payable to the NOCMAS. A reference is thus competent in this instant case. However, in view of the fact that the first accusation proceeding was during 1985-86, the accusation which naturally strikes my mind is, although I find myself competent to make a reference to civil court, whether I should adopt this course or have recourse to some other way to give relief to the poor and indigent Nokmas who has been deprived of their dues for many years. Giving my consideration thought to the entire matter, I find, number A, the case of Balpakram accusation are more than 27 to 28 years old. The illiterate people were paid only 1.5 lakh per square kilometer, which abysmally low by any standards. Due procedure prescribed in LA Act for acquisition of land was not followed, resulting in great economic loss to the rustic Nokmas. The government of Meghalaya wedded to the concept of tribal welfare is perhaps duty bound to mete out economic justice to the aggrieved Nokmas especially. Reference to civil court will not merely consume lot of time but will also be highly expensive for the state. In view of the above, I felt inclined to make reassessment of the land of the acquired with reference to value of per biga of land that existed. So and so, so and so, then comes in the above case, I place the who perhaps is pleased to consider the above views and favor. So, my lord, who passes this order? This is the deputy commissioner, my lord. So this is creating extraordinary circumstances. He himself says he's doubtful. I know. He's two things he's saying here. He's saying number one thing is that the land acquisition proceeding was not followed. This is what he's saying. Second thing he's saying is the government has cheated the rustic villagers. Therefore, we looking into the welfare of the rustic villagers, we cannot shut our eyes. We need to. There is a willingness to give relief. But he's saying that I myself, I'm confused whether I should refer it to the reference code or not. But even if I do a reference code, we'll be putting the illiterate villagers to another proceedings. Therefore, it would be best that we come out with some kind of scheme, reassessed, and what is that comes out, we will give to them. This is the intention. So this is an extraordinary.
So if that is the intention of the government, let the government do it. Why you are before this?
Exactly, my lord. They're not doing. That's why.
See, if
now
they do something,
yes,
at their own level,
yes,
that is a different thing.
Yes.
But then to ask
Yes.
for a judicial order,
Yes, my
you
lord.
must establish a right.
My lord. My lord.
That is what.
Yes. Yes. My lord. I strongly believe that I have. Okay, barring the technicalities, my lord, I have strongly established that I have the legal right to receive the fair compensation. Number one. Number two, on the admission of the respondent themselves that they have abysmally paid me lower than what is supposed to be paid, my lord. Conjointly trying to understand these two, my lord, I have created my legal right, my lord. So that's why I come back again, my lord, that this is an extraordinary. This case is fit to be treated as an extraordinary under category of extraordinary circumstances, my lord. My lord, one more order, my lord. Now, prior to this order, the law secretary, my lord, kindly look at this page 35, my lord. I'm just 35, and the type copy is in the following page, my lord. Page 35, my lord. My lord has page 35.
Page 35.
Yes, my lord, page 35. That is the annexure 6. Annexure 6.
Yes.
And the typed copy is the following page, my lord. The typed copy is not been paginated. My lord has got the.
Okay.
Yes. So may I read, my lord? This is from the Secretary to the Government of Meghalaya Law Department. 2. Officer on special duty to the Government of Meghalaya Forest and Environment Department. Subject: acquisition of land for extension of Balpakram National Park and matter relating to the representation of the President/Secretary of Balpakram Akhing Nogma Social Welfare Association. Madam, in inviting a reference to your letter on the subject above, I am directed to say that, as appeared from the papers, this is the case in which the land acquired in 1985-86 appears not to tally with the land actually taken possession by the government for extension of Balpakram National Park, Balpakram National Park, which comprises of a large area. And as such, poor and illiterate landowners are not in a position to verify regarding the measurement of land. It appears from the papers that an area of 352 square kilometer was taken and that no enough compensation was paid to the effect on the land acquisition assessment should normally be of the land, and the standing trees and the crops loss appears to be not in this case. Hence, it is also that the rate of compensation was paid which appears not to be according to Section 23 of the Land Acquisition Act 1894, and not as the market value of the land, and also as per record maintained by the Garo Hills Autonomous District Council on the date of publication. According to the judgment of the Honorable Guwahati High Court, the matter is to be referred and decided by the District Collector and the Special Judge Civil Court. With regards to the letter so-and-so court case dated 18 August 2011, the point raised by the Chief Wildlife Warden Meghalaya is to be determined by the collector and also by the court, and it should be placed before the collector or the court
What is
for
this
the
case about?
decision.
What is this case about?
Well, this is the legal opinion.
No, that is okay, but then refers to certain case, isn't it?
This refers to the Dikman Sangma's case, my lord.
Okay.
So the first paragraph, further with regards to so-and-so Shillong 18, the points raised by the Chief Wildlife Warden Meghalaya Shillong is to be determined by the collector and also by the court, and it should be placed before the collector or the court for the decision. As such, it may not be proper for this department to offer views before decision of the collector or the court. Legally, the provision of the Land Acquisition does not found place in Limitation Act. However, limitation under Section 18 of the Land Acquisition has to be seen in the light of the Dikman Sangma versus so-and-so, which means whether they have made such application to the authority or not. In the circumstances, the matter is to be decided by District Collector and Special Judicial Officer under Land Acquisition. So the page 36 purportedly, my lord, flows from the legal opinion of the law department, my lord. So this
Was there any affidavit filed in the earlier round of litigation?
I'm not really sure, my lord. In the first
Decision
writ
of
petition,
2008.
that is a writ petition of 2002, my lord,
Yes. Was there any affidavit
for the
filed on
Guwahati
behalf
High
of the
Court.
state?
I'm not really sure, my lord. It doesn't say
this is
so.
what we are asking, my lord. Let the affidavit become first. Why are they shying away? Only on technical things, my lord. Let the affidavit go. Let there a fair adjudication, my lord. At least, my lord, even we don't have that they will be having, my lord. What contention was taken on what premise, in what actual premises this the 2nd March 2011 order was passed, my lord.
No, these orders are of 2011-2012.
Yes, my lord.
Page 36 and the order which we have read out just now.
Yes, my lord. These are all after the Guwahati High Court order, my lord.
And what would be the legal effect of these two orders?
My lord, my lord,
How does it
the
affect
legal
your right?
yes, my lord, the legal effect of these orders, my lord, is creating a stopple upon them, my lord, to even object to that
What
in
is
the
the right
matters,
conferred on you? Forget about what they have been deprived of.
my lord. The right
Say,
yes,
these two. See, you are here. You are before the court
yes, my lord,
for implementation of your right, isn't it?
yes, my lord.
Now you are referring strongly, relying upon these two letters.
Yes, my lord.
Admittedly, those letters came after judicial finding.
This
That's what.
my lord, this created a fair chance of a reassessment, a fair reassessment, a
But
fair,
then, is it not? It should be a voluntary action of the government, not to seek any direction from this court.
my lord. Now,
You have to
yes,
come
yes, yes.
across that legal right.
Today, my lord, today, of course, my lord, today, my lord, that contradictory views that I've shown by the government before, my lord, today, by two letters, my lord.
Two views are there. Then we'll adopt the view which we find in conformity with the judicial order.
My lord, this
What is wrong in it if the court goes by that approach?
don't mind, my lord, my friends. These are quite complicated matters, so I've requested my friend to,
You should have all your instructions before you come.
my lord,
Because court also get disrupted.
my lord,
Every time somebody stands up and sit down,
my lord.
and
My lord.
you can have your instruction and then just reply.
My lord, if my lord allows me, my lord, I will point to summarize my submissions in a bullet, my lord, in a small bullet. That will be
That you can. That will be good if you can.
yes, my lord.
But then before that, Mr. Sen. Now, two things before you come to your defense, you open your argument. After the disposal of the matter in 2008, there appears to be another round of litigation wherein this court had directed for disposal of some representation.
Lordship.
Now, what would be the implication of that order coupled with these two letters?
Lordship. That, in my humble submission, will not create a new right. It will not create a new cause of action.
Why not? Is it not? You see,
Because these are successive writ petitions.
When this earlier round of litigation, the last round of litigation letter, by which this court had ordered for disposal of representation.
Lordship.
Now, apparently, there it seemed like no plea was taken that there is no question of reconsideration of the representation in view of the fact that the court had already dealt with this.
Correct.
Now, there exists another judicial order, right or wrong, separate issue, but then it creates an opportunity for them to get their representation entertained by the government.
Lordship.
Okay. Now, is it not that we can say that an opportunity of reconsideration was created there?
It's only limited to that. It does not create anything further, my lords. And I'll place reliance on certain decisions. But before that, may I just clarify just two things. My friend has given the suggestion that we are trying to hide or suppress certain materials. We are not on the main issue. If your lordships will see, in fact, we had raised the question of maintainability right from the very start, and we had informed the court that we would raise the question of maintainability by way of an affidavit which was permitted by an order dated 24/2/2022. We were not on the issue of merits. We were only on the question of maintainability because the court was prima facie satisfied that in view of the judgment of the Honorable Guwahati High Court, this matter was barred. There was no question of entertaining it any further. So therefore, we limited our affidavit to that. And it is to be heard only on that issue. It has made it to the hearing column. Otherwise, it was supposed to be placed in the admission hearing column. Now, just coming to the issue.
Maintainability matter is yet to be admitted.
Yes, exactly. It is only to be heard on the issue of maintainability.
So now the formality of the issuance of rule has to be followed.
Correct.
Basically, that is the proper procedure in
Correct.
petition which we do not follow anymore now.
Exactly. But my lords had Justice, thank you, had heard this matter on the issue of maintainability and directed us to file an affidavit. So the affidavit is only confined to the issue of maintainability. It's recorded in this order as well. So that is one. Now, the lordships have already seen the order of the Honorable Guwahati High Court. Thereafter, my friend has referred to a letter which has been issued by kindly have page 27. This is a representation which was made by
H
the petitioner, page 27
of their petition.
of their writ petition. Because they are saying that the state has, by its own views and suggestions, created some right in their favor. This is their representation dated 3/2/2012, addressed to the Honorable Chief Minister. Kindly turn to page 28.
Yes.
Let's kindly have para 9.
Yes.
So, Lordships have seen that the Honorable Guwahati High Court had declared that it was too late in the day for them to even avail the remedy of Section 18 of the LA Act. Kindly see what's written in here. We prayed for making a reference to civil court. In terms of Section 18 of the LA Act, the Law Department, after a thorough perusal of the matter, has recommended a reference to the civil court. Where is the application under Section 18? This is a false statement. They made a false representation before the state. There was no such application under Section 18. Next, kindly have page 35.
So what bearing this will have here?
First, it was a false representation made by them.
It's all right to the Chief Minister. But then how do you counter that those two letters by you?
Yes, Lordship. I'm coming to that first letter. Kindly see what is the basis of the first letter. This is at page 35, letter dated 21st December 2011. The typed copy is in the following page, 35A.
Yes. Which was just now referred to.
Yes, by my learned friend.
Mr.
So in the typed copy, kindly have the first paragraph, which begins with in inviting a reference. And kindly see the last sentence in that paragraph.
Yes.
It begins with according to the judgment. If your lordships have it. According to the judgment of the Honorable Guwahati High Court, the matter is to be referred and decided by the District Collector and Special Judge, Civil Court.
Yes.
This is the premise on the basis of which the Secretary to the Law Department writes to the officer on the special duty. This basis itself is incorrect. They have completely misread the orders of the Honorable Guwahati High Court. There is no such direction in the orders of the Honorable Guwahati High Court.
No, but the fact remains that this is your
So,
officer.
this letter does not create a right. I'll just take your lordships to the letter again.
Exactly. That is where we'll have to come.
Yes, it does not create a
Question
right.
is there. You see, these are the letters.
Lordship.
Now, whether these are legally valid or correct or not, this is the issue would be coming. But then before that, the fact remains that these are your officers.
Yes, yes. So I'm saying, let us see what this actually creates in their favor. So kindly see the next paragraph.
Now, the view expressed by your officers, can it be taken as a view of the government?
No, I don't think so.
Why?
It is completely outside the scope of the LA Act itself.
Maybe.
The question has to be that they have to be vested with the right, the legal right to do so. If they don't have it, there is no value. How do we implement this? And I'll just take your lordships through this. This is the first letter. So my friend is referred to two letters. And he cites that these two have created some sort of right in his favor. Whether it's a legal right or not, lordships will examine. But kindly see this letter. I'll just take your lordships to the language of it. Again, kindly have the typed copy, Milord.
Yeah,
The last paragraph here. With regards to the letter number so-and-so, dated Shillong 18th August 2011, the points raised by the Chief Wildlife Warden Meghalaya Shillong is to be determined by the collector and also by the court, and it should be placed before the collector or the court for their decision. As such, it may not be proper for this department to offer views before the decision of the court or the collector. He's restraining himself. He's not creating any right in their favor. Then he goes on to say, legally the provisions of the Land Acquisition Act...
Now for restraining himself, was it needed?
Not needed at all.
Right, such a big...
It was not needed.
See, so we do not know whether it's a letter restraining himself or expressing himself.
Exactly.
See, this is, it seems like it has been done, something like that. Probably this officer was very much aware that what he is doing may not be in the best interest of the government.
Correct. Quite possibly.
And that is what probably you see, like he has used. See,
Very evasive
the
language.
question remains. Question what basically is that after the disposal of the matter in 2009,
Lordship.
why there is a need for the government to reopen the issue?
I would not say it was the government, just some officers. What impelled the officers to make these letters, I really can't make a comment on that.
Then what is the follow-up action of the government? So
I'll come to it, my lords. So this is one letter. Kindly see the last paragraph after
any
that.
affidavit filed by you in this case?
Yes, only on the question of maintainability.
Do you address this to?
We have not addressed any of this, but I'll take your lordships through that. They kindly send me the last sentence in this particular letter. It begins with "in the circumstances above." In the circumstances above, the matter is to be decided by the district collector and special judicial officer under Land Acquisition Act, or through civil court, or as the case must be by mutual settlement. Advocate General was also consulted. So, what right has been created in their favor? They are saying very, very clearly, go to the court, follow the Land Acquisition Act. And the Honorable High Court has already decided that issue.
But then what happens if you read these the two letters?
So then kindly come to the second letter. Now the second letter is in the following page at page 36. Kindly have page 39. So let us see what is the basis of this.
Yes.
Page 39 is the conclusion. This is issued by the Deputy Commissioner. The last two paragraphs, my lord. It says, in view of the above, I feel inclined to make a reassessment of the land acquired with reference to the value of per bigha of land that existed as per district council's valuation. This itself is legally lacking basis. At the relevant period, which is enclosed, my actions find ample legal support in a division bench decision of our Honorable High Court in Winkle-Starr's case. Winkle-Starr's case has nothing to do with this matter. The facts are completely different.
See, it's all right. See, like
So-
it is one thing is that, see, Mr. Shan,
Lordship.
you are trying to dislodge whatever your officer has said
Lordship.
on the basis of the reference made here
Lordship.
to determine the correctness or not.
Lordship.
But then the question still remains: what was the need of issuance of this?
Absolutely no need, my lord. Absolutely no need.
Then what you have done? See, which way? Because
So
you
again,
see,
once we did not address this issue on merit.
If you take it as a government view, we may not go and determine whether it is legally correct or not.
Lordship.
We accept it as a government view.
Correct. This is not
Okay.
final. This is
Now,
again not
your-
final.
Your argument is just like a lawyer scrutinizing a thing,
Lordship.
and you see trying to find out the very basis on which this order has been.
Right.
Okay. Now, this you do when it comes for you to dislodge the findings record.
Lordship.
But then what we are saying is that what was the need of, you see, like, what situation propelled them? 2008, final disposal,
Lordship.
matter ends.
Correct.
Then why these two communications, 2011, 2012?
So we've not addressed on merits. I'm conceding that very readily. Like I said, as per the last order, one of the orders of this honorable court, we
And
were
then
only
even
directed.
see, keeping aside these two also, the subsequent order by High Court, wherein the High Court had directed consideration of a representation which pertains to the same subject.
Only with regard to consideration of a representation does not create a right. Does not create a right, my
See,
lord.
the representation stood rejected, but then
Exactly.
government had the liberty to allow it also. And
Correct.
that representation was touching the affairs.
I understand, lords. I'll take your lordships through that. I'll complete my submission on this. I'll show lordships I'm taking support of certain decisions of the Honorable Supreme Court. What is the effect of successive representations that are filed? Does that create a new cause of action or not?
See, you just confine yourself to become more specific that what is the effect of a representation,
Lordship.
okay, and passing of order by the executive, where the matter was given a quietus by the judicial.
Lordship.
What effect that is?
Yes, yes. I'll come to that.
What bearing an executive action on a subject matter which stood finally decided by the judiciary will have.
Okay.
That is what this court precisely needs. You need not
Lordship.
have to give any other.
Lordship. But I'll just complete it. I'll just take a minute of your lordship's time. Kindly see then the last paragraph of the same letter at page 39, just to show whether any legal right has been created, because that is the first question that lordship had asked. Kindly see the last paragraph. It reads, in the above premises, I place before the government, who may perhaps be pleased to consider my above views. That's all. He's laying down that possibly because they've not been paid sufficiently, they should be paid as per the rates of the district council. and he's placing his views before the government for consideration. That's all. He has not laid down the new assessment. He has not come out with new
Is
rates.
there anything to show that you have not accepted his view?
Yes, by the subsequent letters, my lord. Because this was not implemented. So they were aggrieved, they filed a writ petition.
Subsequent Of that 2019 letter
Yes.
should be treated as a rejection of it.
Rejection, exactly. So they were aggrieved with the fact that they filed successful writ petitions even thereafter. And finally, they filed a writ petition. And lords will kindly see what was the prayer in that writ petition. That writ petition is at page 57.
Now, it's okay. Probably too much interference by court disrupts your submission. The problem is that, Mr. Sen, the court has also its thinking.
Absolutely, absolutely. I have no problem with your lordship.
Right at that moment, if that question is not put, then
correct.
question is
I
lost.
understand.
It gets lost. That is
I'm ready for those questions. Kindly have page
Yes.
57.
Yes.
This is the second writ petition that they filed, WPC 500 of 2018.
okay.
And the prayer is at page 61.
Yes.
So it reads, page 61. Lordships have it. In the premises aforesaid, it is therefore prayed that your lordships may be graciously pleased to admit the petition, call for records, issue rule calling upon the respondents to show cause as to why a writ in the nature of mandamus should not be issued, directing the respondents to make payment of compensation as per the report of the respondent number 4 dated 17/8/2012. This was the prayer in the second writ petition.
That is the 17.8 is the
Report of the deputy commissioner, where he says that possibly there should be a representation, and he places his views before the government for consideration.
this which Mr. Yobin is now interpreting.
Yes,
in
he
his
creates.
favor.
He claims that this creates a right in his favor,
So
and I'm
the-
saying those
the
are merely
prayer
views.
This prayer was not allowed.
Not allowed. What the court instead directed is at page 63.
Yes.
63 is an order dated 11/2/2019.
Yes, we have seen it right now. Mr.
My
Yobin
lord,
has taken up.
only directing the government to consider the representation and dispose it of.
Now, this order was passed in this case.
Yes, my lord,
So it means the prayer which was made was not entertained.
was not allowed.
What is the
So
effect?
it will be,
of
it's a rejection of the prayer.
that? What is the effect?
Not granting means a rejection. Not expressly granting a relief is amounts to rejection.
Where it is provided in law?
I have some decisions, my lord. I can place that.
Is there any provision in CPC?
No, not
Like
I'm
say like if you make a specific prayer before a court
not.
and the court doesn't grant it, can subsequently you renew that prayer?
I don't have it committed to memory at the moment, but I believe it should be under Order 20, if I'm not wrong.
Even
I'll have to
rejection
just
of
examine that.
SLP, even rejection of an SLP in one line, that's
No,
not
that's a
amount to
different issue.
anything.
That is a different
It's a
issue.
question of merit.
That's a different
Here,
issue.
here the court is on a different part.
That part.
There is a specific prayer by you,
Yes,
and it was not done.
not granted. It amounts to a rejection.
Now, probably you both are all experienced counsels and all.
Ah.
Probably there exists a provision
My lord,
in
yes,
law
if
which deals with that issue.
yes. And if my lord will see the page 62, I'm just taking 1 minute of my friend's time and say that address the respondent number 4 and prayed the respondent number 4 may be directed to dispose of the representation. So when on a day when the hearing took place, we prayed. We
So
prayed.
they diluted their own prayer.
we
Kindly
prayed.
see what they did.
No, see, we are not scrutinizing
yes,
those.
but
Do
no,
not,
no,
do not go to that action. This court
Yes.
will not scrutinize all those things
Yes,
and
my lord.
determine the things.
My
We are just trying to determine what is the effect of those.
My lord.
You see, whatever has happened had already happened. We cannot
Yes.
change those situations.
Yes, my lord.
The fact remains there was a specific prayer, and that fact remains that there is a specific way when that case was by which this case was disposed.
My lordship.
Okay,
So-
so it is undeniable that the prayer which was made, it was not done.
My lord.
Lordship.
Okay. Now, what would be the consequence of that?
Mhm.
So, in these proceedings, that is what this court is trying to do.
My lord.
Okay. Now, Mr. Chen, now then you pointed out the prayer and then
So-
pointed out to the sir.
Again, I'll just summarize that, my lords. They asked in that writ petition 500 that they should be paid compensation as per the report of the DC dated 17/8/2012. This was not allowed.
Not done.
Instead, what was allowed is that the respondents were directed to dispose of their representation by a speaking order. Now, that speaking order is at page 65.
Okay.
There again,
Yes.
with reference to the judgment of the Honorable Guwahati High Court, the prayer was rejected. If I may just read that relevant part, is at page 66.
Just. Page 66.
66.
Yes. There is a rejection order.
Lordship.
Yes.
Kindly have the last paragraph.
Yes.
Considering the whole gamut of the petitions filed by the
Of page 66. Yes.
66.
Yes.
Considering the whole gamut of the petitions filed by the Balpakram Aking Nokma Social Welfare Organization, I find that the petitioner cannot agitate anymore to challenge the quantum of compensation paid to them, as they have executed the agreement with the Forest Department accepting the rate of compensation at so and so per square kilometer, inclusive of all costs prior to payment of compensation, which are matter of record. The remedy available to them under Section 18 of the Act, which has now been replaced by the new Act, which is also a similar provision like Section 18 of the old Act, in Section 64 cannot now be relied upon by the petitioner due to time bar. The time limit provided for reference to the Land Acquisition Code in Section 18 of the Act is maximum 6 months, while Section 64 of the new Act provides a period of 1 year if the collector is satisfied that there was sufficient cause for not filing it within the period specified. As has already been observed by the Honorable High Court of Guwahati, Shillong bench, it is now too late in the day to challenge the award made some 7 to 15 years before. I do not find any section of law under which the petition of the Balpakram Association can be entertained in the present circumstances. Having accepted the quantum of compensation in full without protest, they cannot at the same time challenge it after a lapse of several years. Hence, the petition for enhancement of the compensation filed by the petitioners is found to be baseless and not maintainable. They asked the court for an order for consideration of their representation, which was allowed by the court by a judicial order. So this is the final outcome. Now they're unhappy with this. They want to now go back to the original report. That report stands dislodged. Now what is the prayer in this writ petition? Can you see the prayer is at page 7?
Page 7.
Page 7.
Yes.
It says, in the premises aforesaid, it is therefore prayed that your lordships may be graciously pleased to admit this petition. I'll just come to the relevant part. Issue a writ in the nature of mandamus, directing the respondents to make payment of compensation as per the report of the respondent number 4 dated 17/8/2012. Identical prayer.
That is why that question was put by
Lordship.
this court to you, that in the earlier round of litigation, this prayer was made before the court
Lordship.
to allow compensation basing on the same common.
Correct.
Now, this prayer, in view of, you see,
The implied rejection.
that is why.
Lordship.
Can this prayer be renewed here?
Not sustainable.
What is the law?
Not sustainable.
Give us something.
Lordship. So I was not ready with this question. I'll come back by tomorrow. Kindly have it tomorrow.
You are a seasoned man. You cannot say it. No, Mr.
I
Yovin
understand,
also
sir.
will be giving bullet points of.
Yes, my
Right.
lord.
Right.
When you can do it, Mr.
My lord, kindly, because I have
Do not
some-
delay it too much. This court forgets.
Yes,
That
my
is
lord.
So we'll have it tomorrow, my lord.
Tomorrow, my lord. Because tomorrow,
the-
some
Give it in writing.
yes, my lord. Because then have it after 2 weeks, my lord. That'll be final, my lord. That'll be final, my
2
lord.
weeks may be too long.
So because I have to travel for my son's admission and this
The
thing,
application of mind of this court also.
my lord.
That is what is the thing.
Mhm.
We understand definitely you need some time to prepare bullet points.
My lord.
But then, if it is too long for 2 weeks, then again,
Lordship, I'll place reliance on 2 decisions, my lord.
yeah, you want to sum up now?
Lordship. And along with that other issue, that implied rejection amounts to, not granting of relief amounts to rejection, I'll place that judgment as well.
You are ready with those judgments.
No, I'll place it by tomorrow, if your lordships permit, for this case
Tomorrow
to be
we are
listed
not having it. In any case, Mr. Yubin will not be
on the
able
next
to-
date then.
Next day, my lord. Can you give me a copy?
So then you give all those your citations together.
That
You
your
do not do it
compilations,
like
citations. I will also share my compilations, citations, my lord. And because
But you do not make it very voluminous. Do not make
my
it
lord,
a
it's
huge
not good.
thesis kind of thing and
No, my lord. It will not be, my lord. I'll
only just bullet points. will
yes,
bullet
my lord.
points.
I'll give you only
Finish the
bullet
single
point.
line,
Yes, my lord. because what my friend has just read out, my lord, the speaking order, the impugned speaking order, my lord. That impugned speaking order is completely covered by the case of the Winkelstar Thermolong. If he is only relying on that order, my lord, this case is more than sufficient, my lord. Winkelstar, my lord. The same nature of case, the same process.
No, Winkelstar is completely on a different footing. Actually, it's completely different.
The law that has been laid down,
No,
my
the
lord.
laws in the context
My
of
lord,
those facts.
we'll submit this. We will do one thing, my lord. What I have submitted, I will give in the bullet points, my lord, and also the questions that has fallen from my lord. I will support with my judgments, my lord. And let this be a final hearing day, my lord. Let's treat it as
Hearing is more or less it is
yes, my lord,
completed.
my lord.
Only
So the
those
yes,
you see points of law on those specific.
yes, my lord. And then
Okay,
thereafter,
that what would be the effect of passing of executive order in a matter which judicially stood finally determined?
my
The
lord.
one thing. Second thing is the prayer which has not been granted.
Yes,
Okay,
yes.
whether the same prayer can be repeated in subsequent.
Subsequent,
Okay,
my lord.
whether it should be treated as rejected or not, that is what probably
My
you see like. Then these are the main
My lord.
issues.
I'll try to search some judgments in my favor in this
And
line.
then you see,
Yes,
like if a bar is created by law,
my lord, my lord.
like the
Yes,
question of delay of lectures,
my
which
lord,
has been held in 2008.
my lord.
Thereafter, can this court travel to the
That I have
merits on
that
an
I have
issue?
judgment, my lord. I will support at least
Anyway,
3-4
let's
judgments
suppose
are
it.
there, my lord.
When shall we have it? You see, like it is
We can
repeatedly
fix.
hearing it and all, it becomes useless if it is.
My lord, after 2 weeks, my lord. Any date after 2 weeks, my lord.
Mr. Shen,
What?
are you comfortable with that?
What date are you?
What date? Date, money, July.
No, 2 weeks after 2 weeks. You'll not give a specific date. We'll have it after 2 weeks.
Lordship.
Or we can have it. Oh, okay, my lord. No date after 2 weeks, my lord.
You also will be giving bullet points, or only it is for him?
I'll also provide bullet points.
Learned counsel for the parties. Learned counsel for the parties have been heard. It is submitted that the respective parties will find a written gist of their argument in the case. In view of the submission, this matter stands adjourned for 2 weeks. In the meanwhile, the parties will prepare and exchange their gist of agreement.
Yes.
Beforehand.
We'll have actually, you will exchange it before you file it?
Yes, my lord. Yes.
Before the next date.
Yes, before the
Lordship.
next. In the meanwhile, the parties will prepare and exchange the written gist of their argument. The gist of the is gist of. Please refer to this. The government, by its own action, unnecessarily gives some cause
Lordship.
for litigants to come to court.
True. And we have to defend those.
And for that, you have to pay some cost, probably.
If the government does not make mistakes, my lord, then
No, but I'll satisfy my lord. That still does not create any right in their favor.
Even if you refuse their prayer,
Yes, even if I do.
can we grant them some cost in their favor?
Then in that case, I'll ask your lordship to kindly
Then
go through the order sheet.
It may not make litigants happy, but then lawyer will be.
Yes.
oblige, your lordship.
Oblige, your lord.
Item number 12,